Weiss or Ms. Wolf would have given a heads up to Hunter Biden's legal team that the search of the storage unit was forthcoming?
I'm not going to get into hypotheticals about this.
For somebody that was involved in the investigation at that point, who was literally delaying obtaining potential evidence in the case, do you think it was appropriate that then she was involved in the negotiation of the IRS deal with Hunter Biden?
I'm not actually following the question. I'm an assistant U.S. attorneys who participate in investigation, also participate in prosecutions. Is that what you're asking?
Attorney General, I appreciate your time here today, but I'm concerned that these facts are just some examples of what's been going on here where, I apologize, I know my time's out. I yield back. Thank you for your time.
Time of the gentleman's expired. The gentleman from Maryland is recognized for unanimous consent.
Thank you, Mr. Chairman. I guess I had my 5 minutes. I would ask for the unanimous consent to offer some exhibits. First, I would offer
Without objection.
District Attorney Bragg's March 31, 2023 letter in response to the committee.
Okay.
I would offer the letter from Attorney Abby Lowell, Hunter Biden's attorney, to the Committee of Judiciary Oversight and Ways and Means, dated September 14, 2023, and its attachments.
No objection.
I would offer the letter from Ms. Willis to the chairman on September 7, 2023.
Without objection.
And I would offer this article from CNN, Annie Grayer, top IRS official, latest witness to dispute allegations from whistleblower on Hunter Biden tax case.
Without objection.
Thank you, Mr. Chairman.
You bet. The gentlelady from Wyoming, Ms. Hageman. We got.
We have been investigating very serious charges made about your department and other elements of the Biden administration, which allege ignoring the law to protect political allies from being held accountable for their wrongdoing. One aspect of this allegation, brought by two very credible whistleblowers from the IRS, demonstrates a strategy of delaying criminal investigation into Hunter Biden and blocking any investigations into the corruption of Joe Biden. The whistleblower testimony notes that U.S. Attorney David Weiss in November 2022 allowed the statute of limitations to expire, even though Hunter Biden's attorney had already agreed to extend the statute on the 2014 and 2015 charges, which charges included an attempt to evade or defeat taxes and the fraud and false statements related to the $1 million that Burisma paid to Hunter Biden while his father was vice president. During a recent transcribed interview with the committee, FBI officials from the Baltimore field office refused to answer questions about the expired 2014 and 2015 tax charges because they were allegedly part of a, quote, ongoing investigation. Are the tax charges related to these years, in fact, part of an ongoing investigation?
Again, I have no familiarity with the details of this particular investigation.
So you don't know one way or the other?
That's right. I left it up to Mr.
So how are
Weiss.
charges for which the statute of limitations have already expired part of an ongoing investigation?
Again, I don't know anything about this case.
So why would charges that have already expired because of the statute of limitations be part of an ongoing investigation?
To answer in the hypothetical, because I don't know the facts, often charges from previous times are used as part of an ongoing investigation to inform information about intent, about patterns and practices.
For other investigations? So are there other investigations into Hunter Biden where this information may become relevant?
I think it's a matter of public record that there is a tax investigation of Mr. Hunter Biden with respect to other years.
Beyond the 2014 and 2015?
Beyond the ones that are that you were referring to, I think
Mr. Garland,
Mr. Weiss has already said that during the plea proceeding.
Okay, Mr. Garland, is it standard operating procedure in your Department of Justice for prosecutors to allow the statute of limitations to expire on very serious crimes when the potential defendant has already agreed to an extension?
So there, as I said before, there's no standard operating procedure here. This is
maybe there should be.
Well,
If this is an oversight hearing, maybe there should be. Maybe you should adopt standard operating procedures to avoid this kind of a circumstance. Would you agree?
No.
Okay.
Because it's left
According
to
to
the
one of the
discretion
IRS,
of...
you've answered my question, thank you. According to one of the IRS whistleblowers, quote, the purposeful exclusion of the 2014 and 2015 tax years sanitized the most substantive criminal conduct and concealed material facts, end quote. How can Americans trust an investigation run by a special counsel who, by allowing the statute of limitations to expire, irreversibly, quote, sanitized the most substantive criminal conduct and concealed material facts?
The prosecutor in question is an experienced veteran career prosecutor who was appointed by
And we have
President,
no reason to trust him, do we?
by President Trump.
Okay. How much in terms of taxes would Hunter Biden have owed on the $1 million he was paid by Burisma?
Well, as you can imagine, since I don't know anything about the facts of the case, I can't answer
Probably
that
about
question.
$400,000. Isn't that right? I mean, you can do the math. You know the tax code.
I don't know anything about the facts of this case, so I'm not able to do the math to apply it to
And
facts
by failing to
I don't
pay
know.
the taxes on those ill-gotten gains, what would the typical penalty have been, for example, if it was someone who didn't have the last name of Biden or a D behind their name?
I'm sorry. These are all questions you'll have to direct to Mr. Weiss, and Mr. Weiss will address in his final...
By allowing the statute of limitations to lapse, did Mr. Weiss effectively gift the tax money Hunter Biden owed for the 2014 and 2015 tax years to Mr. Biden?
to say again, the decisions about whether in this area and whether these allegations are correct are ones that Mr. Weiss will be able to answer.
Mr. Garland, one of the things you have done over and repeated over and over and over again is that to point out that Mr. Weiss was appointed as U.S. Attorney by President Trump,
Yes.
as though that somehow inoculates him from criticism by us. Is that really how this game is played? That if someone is appointed by a Republican, then they're supposed to be on the Republican team? Or if they're appointed by a Democrat, they're on the Democrat team? You were appointed by Mr. Biden, weren't you? Are you on the Democrat team?
Let me just be clear. The point of that he was appointed by a Republican counteracts the claim that this was a partisan decision to benefit Democrats.
He remained as a member of the Department of Justice.
Mr. Chairman,
under
Mr. Chairman.
Time of the gentlelady has expired. The gentleman from Maryland is recognized again for a unanimous consent request.
Thank you, Mr. Chairman. I want to offer into evidence the testimony or segments of the testimony of Thomas Sobocinski, dated September 7th. It was taken here and before this committee. Goes to the deconfliction issue with respect to Hunter Biden's security detail and the search warrant
Without objection.
executors. Thank you.
Chair now recognizes the gentleman from California.
Good afternoon, Mr. Attorney General. Do you believe Christopher Wray is a competent director of the FBI?
I think Mr. Wray is a person of the highest integrity, for whom I have great admiration, who has extraordinary experience, both as
Thank
a
you.
career
And so you
prosecutor.
certainly don't think he would knowingly give false testimony to this committee, do you?
I am sure that he would not.
Are you aware that Director Wray a couple months ago in sworn testimony implicated you in a sweeping abuse of power?
I doubt he would characterize whatever he said in that way.
Well, he testified about the school board memo that you issued on October 4th of 2021, in which you mobilized federal law enforcement powers against American parents. Now, of course, you didn't put it quite like that. Instead, you found a pretext, which is stated right here in the first line of the memo. In recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence against school administrators, board members, teachers, and staff. What was your basis for making that claim?
I will say again, as I've testified numerous times in response to exactly the same question, that I saw numerous reports in the press of violence and threats.
You saw reports in the press, and so you decided to instigate a nationwide law enforcement initiative?
If I may be permitted to answer the question.
Please.
Numerous reports in the media of violence and threats of violence against school personnel of all kinds.
Did you consult with the FBI director?
We received a letter from the National Association of School Boards reporting.
Yes, that letter contained anecdotes. It didn't contain data of an increase. Did you, yes or no, consult with the FBI director before issuing the memo?
I don't believe I spoke with the FBI director, no.
Why not? Why wouldn't you consult with the FBI director?
Because the purpose of the memo, as is very clear from the memo, is to ask the FBI to assess the situation, to hold meetings, and to determine whether this
Mr.
was...
Attorney General, you started with a conclusion that there was an increase in threats. Now, if you had bothered to consult with the FBI director, here's what he would have said. This is from his sworn testimony, that he was not aware of any such evidence. So my question to you, sir, sitting here today, is can you substantiate your claim that there was an increase? Of course, there will always be sporadic criminal activity in all quarters of society, but your claim was there was an increase. Can you substantiate that sitting here today?
I can substantiate that by the reports in the press of violence and threats of violence and by the letters sent by representatives of thousands.
That's a no. You're giving us anecdotes. I'm asking you if you had data. You also said in your memo that you were committed to using the department's authority and resources to discourage these threats, identify them when they occur, and prosecute them when appropriate. Were there any such prosecutions?
The emphasis should be there on when appropriate, and there were no such prosecutions, and that's good news, not bad news.
There were no prosecutions, and in fact, Director Wray said there were no arrests, there were no charges. So you have no data to show us that there was any increase. You didn't even bother to consult with the FBI director, and then there were no resulting prosecutions, even though you said that they were coming. So I have to ask you now, in retrospect, was there a compelling law enforcement justification for the memo?
I think you're mischaracterizing the memo. The purpose of the memo was to hold meetings, to open lines of communication with state.
So is that a no? Yes or no? Was there a compelling law enforcement justification for the memo?
I believe there was a reason to ask for those contacts to be made with state and local law enforcement.
Well, the FBI director disagrees with you.
That's not what the FBI director said.
Look at it right here, Mr. Attorney General. When asked, do you have any reason to dispute the conclusion that there was no nationwide law enforcement justification? He said he didn't.
Either he didn't see the reports or he didn't see the National
This is a
Association of
transcript. I've
Schools.
sent you this transcript, Mr. Attorney General. So my question is this. Will you retract the memo, and by that I mean issue a formal document to the effect that it is no longer operative?
I will not, because there was absolutely nothing wrong with the memo, as I have testified several times already.
Even though your own FBI director says there was no justification for it, you will not retract it?
The memo is mine. It's my decision whether it's necessary to make assessments like this, and I asked the Bureau to make these assessments, and the other...
Are you familiar with the concept of a chilling effect?
I'm sorry, I didn't...
Are you familiar with the concept of a chilling effect?
I'm very familiar, and that's the very reason...
How would you define a chilling effect as it relates to First Amendment
That is the
jurisprudence?
very reason why the second sentence of the memo says...
Please tell me what you consider to be the definition of a chilling effect.
That memo has no chilling effect.
I didn't ask you your opinion on whether the memo has one. I asked you what is a chilling effect.
I'm telling you that the second sentence of that makes clear...
I've read the full memo. I'm asking you, what do you define a chilling effect as?
A chilling effect is when people's exercise of First Amendment rights are chilled by coercive activity by the government, which did not occur here.
So here we're dealing with moms and dads.
Mr. Chairman,
You and I
point
are
of
public
order
officials.
with respect to the time.
Yeah.
Point of order.
The gentleman's time has expired, but it was a pretty darn important question when the Attorney General of the United States can't define what a chilling effect is, so I thought I would let it go a few seconds.
The Attorney General did define what a chilling effect is and said it didn't occur here.
I don't think he defined it. He just dismissed it. The gentleman's time has expired. I thought it was a very important 5 minutes. We now recognize the gentlelady from Florida for 5 minutes.
Good afternoon, Mr. Attorney General. I'd like to return to the earlier discussion about FISA process and the FISC. A number of the members of this committee and of my community are gravely concerned about the well-documented abuses of the FISA process and within the FISC proceedings. In declassified opinions from the FISC in 2018 and 2019, the presiding Judge Boasberg admonished the FBI, stating there still appears to be widespread violations of the querying standard by the FBI, and that there appears to be a fundamental misunderstanding of some FBI personnel about what the standard reasonably likely to return foreign intelligence information means. Mr. Attorney General, what measures has the FBI instituted since that time to ensure that these abuses are stopped?
So we're talking about FBI FISA Section 702?
Yes, sir.
Which is a central part of our ability to find out what foreign nation states, foreign terrorists are trying to do in the United States. When I first came into the Justice Department as Attorney General, I read the opinions you talked about, and they deeply concerned me. And I agreed when I looked into it that there was a misunderstanding by operators as to, and analysts as to what the query standard were. So one of the very first things I did was send a memo to the FBI directing that the way in which the Justice Department, and particularly the FBI, did the querying be examined and that corrections be made. This was an extension of a memorandum that Attorney General Barr had likewise, after he read similar concerns, sent to the FBI at the end of 2020.
And Mr. Attorney General, in addition to other things, the ultimate adjustments included additional attorney oversight, requiring FBI users to affirmatively opt in to search the 702 database, updated guidance and training, and enhanced approval requirements, correct?
Yes, ma'am. All that's true, and the consequence was a 93% drop in the number of U.S. person queries.
Nonetheless, Mr. Attorney General, you would agree, would you not, that there are continued needs to review, analyze, and make additional improvements and safeguards to ensure that we don't continue seeing these abuses?
I do agree.
In fact, in recent weeks, we saw even President Biden's Intelligence Advisory Board make recommendations that we continue to revise 702 oversight and restrictions, including a recommendation to direct the DNI and the Attorney General to research potential technological enhancement to the current oversight framework. Tell me, what technology might modernize and improve oversight of the 702 process?
One of the technologies that has already worked very effectively is to change this from an opt-out to an opt-in set of queries. So you have to, first of all, indicate that you are looking at 702 and not just across the board of the FBI holdings. You have to have a drop-down window which explains why you are going to do this. It's easy.
Does that window require the user to input narrative text?
That's right. That's right.
All right. Thank you, Mr. Attorney General. Are there other technology-specific changes that you would recommend?
Well, I'd like to consider that more. There are various kinds of auditing programs using technology. The National Security Division of the Justice Department has done some of that. The FBI, actually at the request of Attorney General Barr, began an auditing program like that. FBI Director Ray, who also agrees that these kind of non-compliance shouldn't continue, put that auditing program into effect within the Justice Department.
Thank you, Mr. Attorney General. I yield the balance of my time to the chairman.
Gentlelady for yielding. Mr. Garland, in David Weiss's letter to Senator Graham on July 10th of this year, he says this: I was assured that I would be granted special counsel authority if it proved necessary. And this assurance came months before the October 7th, 2022 meeting referenced throughout the whistleblower's, allegations. How was that assurance given and who gave it?
I'm sorry, I think he was talking about 515 authority. Is that what you're? I'm reading the letter now. He's not talking about special counsel authority. It says that I was assured.
515 authority, okay.
Yeah.
Same difference.
Yeah.
Well, not same difference, but same fundamental question.
I understand your point, yeah.
He's making the point that he was assured that this was, he could get this status, and that assurance, came before October 7th, 2022. How was that assurance given and who gave it?
Yeah, I made that clear in my direction, and that was transmitted to him.
So you told him that back before October 7th that he would have?
I'm not going to get into exactly the deliberation of the department, but
there's three simple questions. How was it given? Who gave it? When was it done?
Yeah, I understand. I gave a direction from the beginning that he would be able to bring a case whenever, wherever he wanted to. That direction he heard, obviously, and he confirms that here.
I went a little over time, so I told the ranking member I'd extend to him a few seconds or minutes if he wanted to say a few more things or ask a few more questions, and then we'll...
Thank you. Let me just ask the Attorney General. Mr. Attorney General, you've been asked many questions here which you were not permitted to answer. People asked the question and just asked another question, didn't permit you to answer. Is there anything you'd like to say in answer to anything that you think should be made clear or added?
Look, I'm grateful for the opportunity. I just, again, I want to assure the American public and this committee that the Justice Department follows the rule of law. It enforces the law equally without regard to persons and without regard to parties, and that we do the best we can to follow the facts and the law.
Thank you.
Mr. Attorney General, we appreciate you being here, and the committee maybe have to do something official. I guess anyone who wants to add something to it, they can submit that for the record. With that.